This is LXBN TV, and I'm Colin O'Keefe. Earlier this week, the Supreme Court ruled unanimously against the Environmental Protection Agency in Sackett v. EPA, a case that could have a huge impact on the agency's enforcement authority. Joining me today to discuss the case is Robert Sanoff, partner with Foley Hoy and author on the firm's blog, Law and the Environment. Starting off, can you give us the background here and why the Supreme Court arrived at the unanimous ruling that it did?
Colin, this is an important loss for EPA because it takes away one of the fundamental effective enforcement devices that EPA has, particularly under the Clean Water Act and CERCLA. It may be not under CERCLA here, but the decision applies to the Clean Water Act. And what happened was EPA had issued an administrative order to landowners and told them that they either had to comply with it or they faced penalties of $75,000 a day. What happens is they have no right, according to the EPA, of any judicial review unless and until EPA brings an enforcement action. So there's this enormous coercive effect as penalties are piling up. If the landowners don't comply with the order, they face potentially millions of dollars by the time EPA gets around to enforce them. And so what happened was the court, faced with those facts, said that in fact, EPA has to afford judicial review to somebody facing an administrative order under the Clean Water Act, which takes away a very potent and coercive tool that EPA has for enforcement. Why they did this, just the mechanics of it were that they ruled not under the Constitution, they ruled under the Administrative Procedure Act, saying that the agency's decision issuing the order was a final decision, which was subject to an immediate judicial review under the Administrative Procedure Act.
I see. And in your post on the case, you just wrote this yesterday. You said, quote, "This is not a case about the correctness of EPA's policies. It is a case about government employees not behaving consistent with fundamental American values." What did you mean by that?
Well, I was commenting on the reference in the concurrence opinion by Justice Alito, in which he talked not so much about EPA doing things, but EPA's employees doing things, which is somewhat unusual in Supreme Court decisions to single out the employees of an agency rather than the agency. And I think what Justice Alito, as I understood it, was trying to get at is that this isn't an issue about EPA simply having a misguided policy. It's really about employees misusing their authority to enforce the agency's enforcement authorities, and that really was the point that I was trying to make with that, and it really personalized the decision much more than you normally see, at least that I normally see in Supreme Court decisions.
Yeah, I think you wrote it on it a bit, or maybe it was your colleague Seth Jaffe wrote. There was a lot of very personalized comments inside of the opinions. Almost things bordering on not sarcasm, but things that were very personal and very very opinionated.
Well, I do think there, in Justice Scalia's majority opinion, there was a certain amount of sarcasm. And in fact, when Justice Scalia from the bench announced the decision on Wednesday, he prefaced it with what I think was probably a pretty sarcastic comment, talking about how the landowners who were in Idaho had not observed any ships passing on their land through navigable waters. And it's clear that the court had a certain amount of deep skepticism about the way in which the agency has taken the view on what is a navigable water of the United States. Mm-hmm. So I do think that the decision reflects a certain kind of really skepticism about what EPA has done and the way in which they went about doing it, which I really think is an important part of understanding the decision. In my blog, I think I was really trying to capture that what the court does in its decisions, both the concurrence and the majority, is to really talk about the Congress and the way in which the Congress hadn't really defined what navigable waters of the United States were, which left a large ambiguity about when a landowner gets an order, whether the order is enforceable. And then EPA compounded that ambiguity by taking an even more aggressive view as to what is a navigable water, coupled with not ever allowing any judicial review until EPA decided to do it. And I think the court was really protecting its prerogatives as part of the co-equal branches of the United States to afford judicial review where Congress isn't really doing its job and its judgment by defining what the scope of a statute is, and where the administrative branch is taking a very aggressive view about how to enforce its authorities. And I think the court was in there saying they have the right to exercise its jurisdictional prerequisites and afford judicial review to provide the balance that the Constitution says should exist between the three co-equal branches.
Mm-hmm. Exactly. I mean, they're just preserving their fundamental role. And then lastly, you touched on this a little bit after the first question, but looking forward after this case, this case obviously refers to the Clean Water Act. But what impact does this case have then on the EPA's authority under other acts like the Clean Air Act and CERCLA, which you touched on previously?
And you mentioned my partner Seth Jaffe wrote about this subject, and I think the answer is formalistically the decision doesn't do anything more than affect the Clean Water Act authorities that EPA has. But I think reading the decision where the court specifically did not go and say this was a constitutional due process issue, which would have wiped out this issue, this enforcement technique across the board. They limited it to the Administrative Procedure Act under the Clean Water Act. But if you read between the lines of the decision, it's kind of hard to think that the court isn't sending a pretty clear signal to EPA that they're really troubled by this enforcement technique. It's very coercive. Justice Alito makes it sound as if there's no question but that he thinks this is unconstitutional and absolutely antithetical to any fundamental principle of due process. Whether there are 4 other judges on that court that would agree with him is not clear, although the rhetoric of the decision and the way it's written, I think if I had to guess, I'd say, if I'm EPA, I'd be nervous about testing whether or not I have that right under CERCLA, for example, because I think you could easily find that court coming back and saying, if forced to, that this is in fact a constitutional issue and not merely an issue about the Administrative Procedure Act.
Yeah, I mean, it'll be interesting to watch to see if other challenges come up through litigation, or if EPA employees just cool their jets on using these potentially coercive tactics. So we'll see.
Well, I do think the point you make, Colin, is really the takeaway that I come away, which I read between the lines pretty clearly, that the court is troubled by the way in which EPA has gone about enforcing not just the Clean Water Act, but generally. And I think they are sending a message to the EPA that they should be more circumspect about the way in which they're willing to put parties who receive orders in this double jeopardy of kind of facing these enormous daily penalties without any right of judicial review. And I think it's hard not to read that decision and think that the court is going to be looking hard if EPA continues to do that, even under other statutes.
Yeah, definitely. It's going to be an interesting one to follow going forward to see if this, sends the message that they intend to send. And once again, that was Robert Sanoff of Foley Hoeg. For more on Sackett v. EPA, be sure to visit lawandenvironment.com. Robert and his colleague, as we talked about, Seth, have some great posts up on that blog. And of course, at lxbn.lexblog.com, we have all the posts on the case tag going back months, including Robert and Seth's posts. So be sure to visit that as well. Thanks again for your time on this, Robert.
Thank you.